Um, Good afternoon, everyone. This is the fourth in our series on U.S. and European and North American approaches to human rights. And today the topic is employment discrimination. And I'm very excited to have the two speakers we have, Laura Carlson and Sam Bagenstos. And I'll introduce each of them and then say a word about how we're going to proceed today. So Laura Carlson is here representing all of the European Union and even the Council of Europe. She is an associate professor of law at Stockholm University School of Law. And her research interests include Swedish and European equality, labor, and employment law, as well as comparative law. So she's going to do a little bit of both sides of the comparison, actually. And she's written quite extensively in these areas. She has a number of books, including The Fundamentals of Swedish Law, if you like what you hear and want to know more. Swedish Labor and Employment Law, Cases and Materials, and then Searching for Equality, Sex Discrimination, Parental Leave, and the Swedish Model with comparisons to EU, UK, and US law. As I said, Laura will be able to give us a comparative perspective because she did study law in the United States. She has her JD from the University of Minnesota. And I learned this morning she even went to high school in Arlington, so she can do it in Texas, Stockholm, comparison. And she did all of that before moving to Sweden, where she then got another law degree in Swedish law and entered the academy. Her talk today is entitled "The Delicate Balance Needed When Addressing Unlawful Discrimination, the Swedish Journey." And Laura will speak for about 20 minutes and will be followed by Sam Bagenstos, who is professor of law at the University of Michigan. He specializes in constitutional and civil rights litigation and is one of the most recognized scholars on disability rights in the U.S. But he doesn't know anything about Swedish law. Well, everything he knows he learned from Laura.
That's true.
He's author of many writings, including the books Law and the Contradictions of the Disability Rights Movement and Disability Rights Law, Cases and Materials, and many important law review articles as well. Sam also has significant practical experience. So from 2009 to 11, he served as the Principal Deputy Assistant Attorney General for Civil Rights. And today he continues to consult with civil rights organizations and is engaged in litigation and also testifies before Congress on occasion, including, I didn't realize you had done the same, issues of whether the U.S. should ratify international legal conventions on discrimination. So he knows what hard law and soft law mean, which will be an important part of Laura's talk. After law school, Sam clerked for Justice Ruth Bader Ginsburg of the U.S. Supreme Court, which I only mention because I didn't think Carrie Franklin was going to be here, but she is. So those of you who have read Carrie Franklin's work know her argument that Justice Ginsburg was motivated by Swedish law and her pursuit of gender equality. And part of what Laura is going to do today is to tell us that that might not have been the best place to look. So I thought if Sam felt moved, you could talk about any evidence you might have of those of the influence of Swedish law on Justice Ginsburg. Sam's title, his talk today comes out of his book on disability law, Remedies and Anti-Discrimination. So it's entitled Remedies and Anti-Discrimination Law: The Americans with Disabilities Act Experience. So I want to say it's been really great working with both Laura and Sam in putting together today's event because Laura sent in some materials and then Sam gave, so for the students, those of you, many of you are students here, they seem to be sitting mostly on this side for you all. The name tags have fallen away by the fourth event. But she sent in a work in progress that was really terrific for us to read. And then Sam sent in some parts of his book that connected to some of the issues. So it was, we had a terrific discussion about it last week, and I know we'll continue with that today as we engage in this comparison. So, so after Laura speaks, Sam's going to speak for a little bit longer, actually, responding to Laura's work, as well as putting forth some of his own work, and then Laura will respond for about 5 minutes, and then we'll have a little discussion and bring you all in. So please join me in welcoming Sam Bagenstos and Ursula Carlson.
Well, first I would like to thank everyone very much for being here, for having the chance to come back to Texas after several decades of absence, I can say, and seeing what a wonderful state it still is, and how wonderful the people still are. I'm going to be focusing a little bit, not so much on the actual legislation in the Swedish system, but the parameters around the legislation that I think take from the effect it could have or make the effect a little bit more difficult in the best of all worlds. And as the students who read the two of our articles, Sam's articles and myself, we both have serious concerns with access to justice issues. So I'm going to start a little bit with the parameters, the larger framework, and then go down to access to justice issues, at which point I'm hoping Sam will be able to take over. So the first thing I think from a comparative perspective, and now I am speaking as someone who straddles both worlds, the common law world and the civil law world, and I was thinking more that there would be students here. I didn't understand there would be so many people. So when you think of the law, you've got some assumptions about the law that you just take for granted, you know. And even like in the United States, where we've got 50 states, 50 different legal systems, we have certain fundamental assumptions about the role of the law that I don't think we question too often. But in the European context, I would argue that the law plays a very different function, and particularly in the Swedish context. When we have debates in Sweden, and like a minister will say, well, maybe we need to pass a law about this. And a good example is tattooing, now I'm getting my Swedish mixed up, giving tattoos for minor children. And the proposal was that tattoos should be forbidden for minor children without parental consent. And I think everyone, from the American perspective, that would be a no-brainer. The minister of the Department of Health came out and said he didn't think that we needed to do such an extreme thing as pass legislation on this, and that legislation cannot cure all the evils in the world. And this is not an exceptional attitude towards legislation. Legislation is kind of seen, at least in the Swedish context, as a last-ditch effort because society's failed, right? And so right there you have a very different playing field to begin with, because as I've mentioned in my article that the labor unions were against legislation in this area, and discrimination legislation. They were against it. And that also is counterintuitive. How can labor unions be against discrimination? Because they saw that as a sign of failure of the society, and also as an encroachment of their power when it came to self-regulation. So I just wanted to kind of flag this aspect of the law that I don't think, unless you really become entrenched in two different societies, that you see this fundamental difference in what the role of the law is. And another thing that Sam and I were talking about that I did not perhaps discuss enough in my articles, is the difference between social justice and individual or legal justice. And Sweden is very much a society based on social justice. We have a very high standard of living, and we have very few people who are under the poverty level. But social justice, in some ways, it excludes individual justice. Because what happens with social justice is you say that society as a whole needs to have these levels, but the individuals in the society don't receive the same attention. And the best example I have of that is when it comes to, and this is very counterintuitive to the American experience, but the pharmaceutical industry has been given the power to self-regulate the damages arising from pharmaceuticals, right? So you don't sue in Sweden when you've been damaged or harmed by a pharmaceutical. You go to this board and you get a predetermined amount, and that's how it's handled. And the board, the people sitting on the board are the people in the pharmaceutical industry. Okay, I know that, okay, I think that sounds a little strange from an American perspective, but that's how it is. And if you want to get the damages immediately, you have to sign a waiver saying you will not sue. And so most people, of course, want to have the money in hand. And so there's very little litigation in Sweden with respect to to damages. And I guess I just want to say that, so when we're talking about these discrimination claims, there is this aspect to it too, this idea of social justice as opposed to individual justice. And then another aspect of the parameters is the difference between monism and dualism. In the United States, we're a monistic system, which means that when we sign international treaties, they become the law of the land, at least according to the Constitution. Now, there might be different realities, but that's the starting point. But most other countries, and almost all European countries, have what's called a dualistic system, which means you can sign a treaty, but it doesn't become the law in that country until an act is done. And in the Swedish context, it's actual legislation. So an example here is we signed the European Convention of Human Rights in 1951, and it did not become Swedish legislation until 1998, and that was because it was a requirement of EU membership. So that going out and signing international treaties does not necessarily mean you're creating a platform for the individuals in that society. The individuals in that society have no standing until it becomes a law in that country. And this is a little bit about the origins of soft law. That with soft law, you have on the international public law level, you have conventions that are seen to be persuasive, but the people who are harmed within the terms of those conventions don't necessarily have standing. So when I talk about soft law in the discrimination context, you have the same problem. That if you have soft law in discrimination areas, that means the people who have been discriminated against will not have standing to bring a claim. What the soft law does is it means that the law should be interpreted according to the parameters set out in the soft law, but it doesn't create a basis for any type of legal claim. So, what are the reaches of the law? That's what I've got done. Now I've got to do the next one. So who are the main actors? Well, in the Swedish context, we have an employment law, which has been the majority of the discrimination regulations until 2006 or 8. It's been the social partners, and the social partners are the employer and employee organizations. So what this means is that we don't have a tripartite system in Sweden, we have a bipartite system. The legislator is supposed to keep their hands off the labor market, and the hands off the labor market includes things like regulating discrimination or discriminatory behavior. We got our first act with respect to equality between men and women in the late 1970s. It won by 1 vote because, again, labor was against it. The other acts came mostly as a product of the requirements of EU membership. So not only do you have this idea of soft law versus hard law, but then you get into this, that the discrimination legislation in Sweden was not internally fostered, but externally imposed, which brings from a comparative perspective ideas of transplants and things like that. And then we have the Swedish Labor Court, and the Swedish Labor Court has had a monopoly on the issues of discrimination up until the 2008 Act. And what does that mean? Well, the Swedish Labor Court is often the court of first and final instance. You cannot appeal decisions by the Swedish Labor Court to the Supreme Court. There's nowhere else to go. You can, if there's a violation of EU or a question of EU law, you can do a collateral attack perhaps and bring it to the Court of Justice or the Court of Human Rights. But within the Swedish system, we're talking about this is the court that's the first and final instance. And who sits on that court? It's an arbitration panel appointed by the social partners, and only 2 of the 7 members need to be judges. Okay? So very different attitude. And why is it like that? It's kind of like the jury system in the United States. The idea is that the law should be interpreted by the people who are active in the sector. Okay? So, and this model of a labor court, almost all of the Scandinavian countries have it. But like Iceland, for example, decided explicitly the labor court was for labor disputes, for collective agreement disputes. We're not putting the discrimination issues there. We're going to put them somewhere else. But Sweden went with the model of keeping them with the labor court, so that the labor court will, in one case, make the decision that's final. So you only have the one level of appeal. And then we have the other problem that our ombuds man, the discrimination ombudsman, has a limited mandate, and that mandate is not to bring cases, but to bring cases that are precedential value, which means that if it's already been decided once, one way or the other, then the ombudsman is probably not supposed to take the case. And then, of course, the budget is not very generous either, so we've got that issue there. And then when it comes to discrimination claims, we have procedural parameters. In Sweden, you can only plead on the facts. You cannot plead on belief and then amend the pleadings. You can only plead on the facts. So the plaintiff has to know the facts and actually offer a list of evidence with the complaint. We have very limited discovery, if non-existent, very limited abilities to amend the pleadings. So the plaintiff basically has to know everything about the claim when they file the complaint, which in discrimination cases, it might be difficult to understand what's gone on in the situation if you don't have certain information from the employer. And then the access to justice issues. We've got a couple of things that I think create barriers besides the other things I've been mentioning now. We have a very short statute of limitations. It's measured in months and sometimes weeks. So that when you think you have to plead on the facts and you only have 2 months, it becomes, I think, fairly prohibitive. We also have a system, and this is something, again, that Sam and I talked about this afternoon, so it's not in my article, but we don't have contingent fees in Sweden. Contingent fees are seen as the curse of the United States. And they're just, I mean, truly, it's like this when you mention contingent fees, because it's the greed of lawyers and that there's no other function for it. So we do not have contingent fees. And we have a system, we don't have pro bono either. There's no requirement for lawyers to do anything pro bono. So that there's very little in the way of assistance. Legal aid from the state is mainly only in the cases of criminal defense. And the home insurance policies, of all things, but that's where it is, the home insurance policies have certain provisions for legal fees, but they're very limited. They're limited to about $6,000 total, which doesn't get you very far if you're litigating a claim. The attorney's fees in discrimination cases, the ones that are brought before the labor court, run about 150,000 Swedish crowns, which is about $25,000. So it'll get you a complaint, maybe, but not much farther than that. But then we get to what I think the two last aspects, or what for me are the most predominant with respect to barriers for plaintiffs. We have a very, and I think here we're very much like the German system, as I understand the German system. We have very conservative damages. Very conservative damages. Compensatory damages would be about the same, I would argue, especially if it's something like breach of contract. You're not going to have much of a difference in the damages. The same type of damages mostly are recognized. We do not have punitive damages. So we have what's called, they're kind of normative damages, and what the damages in the recent damages, even with the higher level of damages by the labor court, have been about $10,000. Historically, they've been about $3,000 to $5,000. And when you start putting that against attorney's fees that are $125,000, you can start to see that you have to do a cost-benefit analysis. Right? And then we have, in discrimination cases, we have no fee shifting. So we have the English rule. And the English rule is that the prevailing party's fees will be paid for by the losing party. And I had 2 cases in the article, and then I had a couple of cases showing things. And one of the cases was a man who had sexually harassed a young woman at the workplace. He sued before the general trial court with respect to unlawful termination and was successful because under the labor court's case law at that moment, he could not be fired because you cannot fire at will in Sweden. He took it to the labor court, and this is a case where the labor court changed its case law a bit, and it made it at least more that the employer would not have to put up any type of sexual misconduct in the workplace. And so he lost the majority of the claims that he brought, and since he lost the majority of the claims that he brought for the unlawful termination, the labor court said that he needed to pay the attorney's fees for both instances. And for just the employer, we're talking 250,000 crowns, which is about $40,000. And this is someone who's unemployed, right? I had two cases that I had in the article. The first case was a case by the labor court, if I remember correctly, and that was a case where a person of African descent from Gambia was working in a municipal care center. And at this care center, they had a way of speaking about him at the workplace where they called him things. Some of these things don't make sense in English, but the Swedish equivalents are not good. But they called them nigger, kuntkinte, blackie, blackhead is another one of the ones, svartskola. Called him all kinds of derogatory things at the workplace. So he sued for discrimination. And the labor court found that in this case it was no unlawful discrimination because they said it was banter in the workplace. And again, okay, if you can appeal the decision somewhere, right? This is the final court. So we have this terrible case from 2000, I think it was 8 or 9, about this person being exposed to these different names, and there was some kind of consent to it. The other case that I brought up was the law students case, and this is where the law students had divided themselves into 4 teams. 2 teams were the blonde-haired, blue-eyed, right? And then 2 teams were, and we're not even talking skin color now, we're just talking black hair and brown eyes. But everyone had the same clothes, same hairstyle, and made sure everything was very much the same. And they brought with them video equipment because we have a law saying it's unlawful to not allow access to public facilities because of hair, skin, ethnic origins and stuff like that, but it had never been successfully prosecuted. So these law students decided they were going to try to bring a case. So they sent in the brown-eyed, black-haired team, and they were, oh, do you have a VIP card? Are you on the waiting list? And no. He said, unfortunately, you can't come in. Then they sent in the blonde-haired, blonde-eyed team. Oh yeah, come in, party, yay. So then they sent in the brown-eyed, black-haired team again, and it was again, are you on the waiting list? Do you have a VIP card? And then they sent in the blonde-hair, blue-eyed one more time. Now what's so interesting about this case, in the trial court, the defendants were found guilty of unlawful discrimination. There's a no-brainer. And again, the defendants got 20,000 Swedish crowns, which is about $3,000. Okay, so we're not talking like they got rich on this. 3 plaintiffs. Went to the appellate court. The appellate court said, yes, we will, this is fine, no problems. Went to the Supreme Court. And the Supreme Court said, yeah, well, we understand that this is unlawful discrimination, but we think that since the plaintiffs or the petitioners did not have any actual belief that they would come into the restaurant because they knew they would be discriminated against. And we find that since they actually taped all of these actions, that the public would lose confidence in the law if they knew people could enrich themselves by bringing such claims. So we find that the combination of the enriching and the not thinking you're going to get in anyway, so you had no harm, means that we can reduce the fees to 5,000 crowns, which is about $700. Which, again, brings this question. I think the legislation's fine, right? I think the legislation's fine, but we have a very different attitude about what the legislation is to do in a society, and then we have a very different attitude about seeing plaintiffs in certain situations. This was a very liberal judging by the court. The parties were equal parties needed to be treated equally, right? And actually, you almost got the impression when you read the case in Swedish that they felt a little sorry for the bar owner because he didn't think he'd ever get caught doing this. So it was a little unfair that he actually got caught. It just feels a little bit like that when you read the case. So we have legislation, and I think that the bottom line is that it's not enough with legislation, that you have to have a legal cultural surrounding to allow the legislation in any way to receive true effect. And I think here, I've succeeded in showing some of the, what I would argue are impediments to making the legislation effective in any true sense. And I think I'm just about exactly out of time, right? Well, I think I can.
That was perfectly timed.
Excellent. Okay. Perfect. So this is, I really appreciate the opportunity to talk here. I am a very non-comparative person. I have no expertise outside of the United States, but I'm very interested in talking about the way in which kind of there are limitations of our models of dealing with problems of equality in the workplace particularly, but also outside of the workplace. And what I find the more that I engage in conversations with people from other systems is that we have this grass is greener phenomenon, right? So it turns out that we very acutely see the flaws of our own system, and we think that there are terrific things just over the border, and there may be lessons to be learned just over the border, and I think there are some lessons to be learned just over the border, or across the Atlantic and in Scandinavia. But maybe what our discussion today will give you a sense of, and certainly gives me a sense of, is the degree to which, although the problems end up getting channeled through different legal doctrines and different legal systems, a lot of the problems are very similar across different nations. So I'm really happy to be able to engage in that discussion today. I really appreciate Karen talking about Justice Ginsburg. And when I read Carrie's terrific article about Justice Ginsburg, what I said when I read it was, yes, Justice Ginsburg couldn't stop talking about how much she loves Sweden. Like the entire year I clerked for her, it's like Sweden this, Sweden that. It's like, I get it, it was your first job out of law school as you wrote, a book about civil procedure in Sweden. But clearly Sweden was very influential on her, and I actually felt like I learned so much from that paper, and it is nice to be able to talk about the equality approach in Sweden now. What I want to talk about substantively, one way of thinking about it actually picks up very nicely where Laura left off, which is I want to talk about what happens even if you have hard law. So even if there are laws that encapsulate whatever your vision of equality or whatever your vision of justice is in the civil rights area, do they lead to the achievement of that vision in practice? And most of what I'm going to talk about, just because it's the area I spend most of my time on, it will come from the disability rights area in the United States. And if you look at the disability rights movement in the United States, which is a very significant social movement, really coming together in the 1970s, working very hard and self-consciously to build a movement across disability, to create a series of political and cultural asks, and to really get a lot of what it wanted. What you see is a demand, not just by the lawyers, not just by the elites, but by the rank and file, by a huge swath of the movement in the United States disability rights movement, a demand for law, and for a particular kind of law, for civil rights law, for the idea being a move from law promoting social welfare, a move from law promoting cash payments, promoting transfers, and instead to law providing for equality, anti-discrimination. this is central to the way the American disability rights movement, I mean, to the extent you can think about a movement as being unified in any way, thinks about itself. And in fact, broad swaths of the American disability rights movement really talk about law and civil rights law, anti-discrimination law as the thing that we want. And if you look at the disability rights movement in the United States from that perspective, it looks very successful, right? You have this movement coming together over the course of just about 20 years. From 1972, the independent living movement is founded in the United States with the founding of independent living centers in Boston and in Berkeley, California, and in Chicago. From 1972 to 1990, when the Americans with Disabilities Act is adopted, you see the disability rights movement in the United States, 18 years, achieving its central aim, which is a comprehensive anti-discrimination law that prohibits discrimination against people with disabilities across wide swaths of American public and private life, in employment, in public services, in places of public accommodation. And you see this law being passed very successfully with very, very substantial margins in Congress, signed by George H.W. Bush, whose namesake airport I flew through this morning, which I'm being taped, so I'm not going to say any more about that. But signed by George H.W. Bush, and really a bipartisan approach by both Democrats and Republicans. You see very substantial support for this law. Okay, so as of 1990, looks like this movement's very successful. Fast forward, and what do you have in 2000, or in 2010, or in 2014? What you have is the non-employment rate for people with disabilities is roughly the same as it was at the time that the ADA was adopted. About 2/3 of people with disabilities don't work. Now, the unemployment rate is lower than that because the unemployment rate excludes people who aren't looking for work. But if you look at just the percentage of people with disabilities who aren't working in the United States, it's about 2/3, 60% to 2/3, and it stayed that way for the entire time. If anything, in the initial years of the ADA, the number of people with disabilities working in the United States went down. And then it went up a little bit during the booming years of the 1990s, but not that much. And then you get the recession, particularly the 2007 recession with the financial crisis, and you see the working rate, the employment rate of people with disabilities again plummeting, being hit really hard. People with disabilities being hit especially hard by the recession. So there's some problem of mismatch between the goal of the disability rights movement, which was framed as a law, but an anti-discrimination law is instrumental to certain other goals being integration, empowerment, full and equal citizenship of people with disabilities in the community. There's a mismatch between those ultimate goals and the anti-discrimination law that the disability rights movement achieved. And why is that? And I think this helps to focus us a little bit on why, even if you have hard law, you don't necessarily achieve your equality interests. And it also has certain parallels with the Swedish experience. So two real limitations, two real problems with the model taken by the American disability rights movement. One limitation or problem has to do with limitations in enforcement, so overlapping with the idea of access to justice that Laura was talking about. And in the written thing that I circulated, you see some discussion of this, but let me say a little bit about this, because I know some of you have read it and some of you have not had the opportunity to. So one problem in the United States as well as in Sweden is that when you have anti-discrimination laws, they don't enforce themselves, right? We have actually fairly robust public entities to enforce civil rights laws as compared to probably most other countries in the world. Certainly when I go around to other countries, our public enforcement apparatus, our government agencies devoted to enforcing civil rights laws and anti-discrimination laws seem to be much more substantial than the apparatus they have in those other countries. But still, those enforcement agencies can only take a very small fraction of the cases because it just costs a lot of money. There are a lot of calls on the public budget. So enforcement really relies in the United States on individuals getting their own attorneys. We heard something similar is true in Sweden. In the United States, we do have more robust mechanisms for enabling people to get their own attorneys to enforce civil rights and anti-discrimination laws. We have contingent fees in cases where there are substantial damages. Although in a lot of the cases that we're talking about, there aren't substantial damages. And we have fee shifting. We have one-way fee shifting in the United States, where if a plaintiff succeeds in proving discrimination, the plaintiff can recover not just damages, but also attorney's fees from the defendant. And we don't have the same kind of what seem like punitive and vindictive rules that I read described in Laura's piece about even when you have a successful plaintiff, the successful plaintiff will be forced to pay the attorney's fees of the defendant. That doesn't happen in the United States. Sometimes an unsuccessful plaintiff whose case was found to be frivolous will have to pay the other side's attorney's fees. But in the overwhelming majority of cases, what happens if you lose is your lawyer just doesn't get paid in the United States. It's not as harsh a consequence. Nonetheless, there is a very significant problem even with these incentives in finding attorneys to bring cases under the Americans with Disabilities Act. This is true in the employment context, and it's true outside of the employment context. So I've already nattered on a bit. So let me just talk a little bit about the employment context and then talk about the broader issues. My second big issue. So in the employment context, the basic problem with finding attorneys is that it's very difficult to prove a case that you have not been hired because of your disability. It's very difficult to prove a case that you have not been hired because of any particular characteristic. People who are not in jobs that they want and never got a chance to be in jobs that they want have a hard time proving their cases. Well, why is that? Well, employers usually are looking, particularly in a labor market like we have in the United States for most of the last many years, employers typically are looking at a large number of applicants for a particular job. They may have many reasons that they can assert for why they did not choose to hire somebody, and it's very difficult to prove that they didn't choose to hire somebody because of a forbidden classification. Now, in the context of something like race or sex, it may be easier. It may be easier to prove that because it might be possible to use statistical proof. Something that in Sweden, as I was talking with Laura, I was surprised to learn, is not a possibility, is excluded from plaintiffs' cases. But, in the United States, under Title VII of the Civil Rights Act, one way an individual who is suing to challenge the failure to be hired on the basis of race or sex can prove that is by showing, look, every time you hire somebody for a position like this, you hire somebody who's white, or you hire someone who's a man, yet the qualified applicant pool contains X percentage of non-whites or X percentage of women. There's something wrong here, and that helps to raise an inference of discrimination. Really hard to do in the case of disability because disabilities are so multiple. There's so many different disabilities, and a person may have one disability and not another disability. It becomes very difficult to get a sufficiently large N for any particular disability to prove statistically discrimination. It's also difficult to prove hiring discrimination because of something that I think is maybe a commonality between the Swedish story and the American story, and that's the ideological orientation of judges. It's a commonality in a particular way, at a particular level of generality, which is to say, if what you want to do is tell a story that a set of facts shows that someone was rejected because of a particular status, in order to succeed in proving that story and persuading a decision maker of that story, you really have to tap into something that connects with the decision maker's worldview. And if you have judges in the United States who are increasingly conservative over the past 30 plus years, who believe that discrimination is largely a thing of the past, who believe that, as Justice Scalia wrote in the Walmart case in the Supreme Court just a couple of years ago, well, left to their own devices, most managers would probably make decisions that are on the merits good for the company and wouldn't discriminate. I'm paraphrasing, but that's basically what he says in the Walmart case. If you have judges who believe that discrimination is deviant, who believe that most managers are acting in good faith, or acting with the bottom line, with the bottom line as their concern, and the bottom line is not something that's racist or sexist or disableist, well then, it's going to be very hard to prove discrimination. In Sweden, right, you see something of the same thing, at least in the stories that Laura's talking about, maybe arising out of a different kind of tradition, a tradition of a more labor-oriented tradition, a tradition of really collective bargaining, collective negotiation, but working out to the same thing. Difficult to prove discrimination in individual cases because of the ideological presuppositions and because of the worldview of the decision maker. So I think that's important as well. In the United States, we have increasingly a sense among judges that what we don't want courts to be doing is imposing their own view of proper management practices on employers, on supervisors, right? So you see a lot in the cases. We don't sit as a super personnel agency. We don't sit as the HR department for the companies whose acts we're reviewing, and I think that ties into it. So one problem, one reason why in the disability area, this is also true to lesser extents in other areas of civil rights law in the United States, you don't see the employment effects you might want to see from the ADA, is because of limitations in enforcement. But I think there's also something deeper, and I think what's deeper is limitations on the limitations of the civil rights model itself, of the model of anti-discrimination as the way of achieving integration, empowerment, substantive justice, equality, equal citizenship, whatever you want. And here again, I'm tempted to say, look, I mean, the grass is always greener. I recognize this. Everyone I talk to who is an activist with a disability from another country, and I talk to lots of people in the disability rights movements in the United States and around the world, all the time, they always tell me America is nirvana as it comes to disability. I mean, and there are many substantial strengths of the American response to disability, and I accept that. But there are also many limitations that might actually benefit from looking outside of our system. So the anti-discrimination model in the workplace is a model that is very helpful to people who can get to the door of the workplace, who can get to a place where they are in a position to be discriminated against, right? So if you have the educational qualifications to apply for a particular job and be considered seriously, and if you have transportation to get you to that place of work, and if you have a disability and need this, if you have assistive technology or personal assistance to enable you to get out to the transportation and to enable you to work, and if you can afford to give up whatever health insurance you get from public programs by not being in the workforce, when health insurance in the American system that is for people who work is not designed generally for people with very serious disabilities, if you can overcome all of those barriers and get to the point where you can be discriminated against by an employer, then the anti-discrimination law might help you if we can overcome the proof problems I was just talking about. But if all of those barriers are real barriers to you, if because of your disability and the failure of the community you live in to invest in accessible transportation, you can't get to the workplace, or because of your disability and the failure of the community where you grew up, you didn't get the educational background necessary to be qualified for a job, or because of your disability and the failure of your community to invest in personal assistance or assistive technology or the right kind of universal health care, you don't have the services to be able to apply for this job, then you won't even be in a position to be discriminated against and bring a suit. And one reason I have argued, I've now been arguing this for years, I mean the first place I argued was in an article that Carrie edited 10 years ago when she's still young, when I was young, because I am not young anymore. If you don't have programs, policies to overcome these obstacles, then the anti-discrimination law is not going to help. The anti-discrimination law is simply going to be irrelevant, right? And so one of the things that I have been arguing for a long time is that this historic approach of the United States disability rights movement, which was matched by the approach of the British disability rights movement, matched by, I got to spend, about 8 years ago, I got to spend a weekend with a leading disability rights activist in Sweden who also was saying many of the same things. This approach of abandoning, pushing away from social welfare interventions, pushing toward anti-discrimination interventions, may set up a choice that actually is, if not harmful to the integration and empowerment and independence of people with disabilities, at least not helpful to the integration, empowerment, and independence of people with disabilities. That in fact, some piece of a social welfare state is essential, and increased attention to social welfare programs is essential to promoting the integration, empowerment, independence, or whatever you want for people with disabilities. Now, this raises a lot of questions about what those kinds of social welfare interventions should look like. Because one reason why you had this historic turn away from social welfare and to anti-discrimination by the American and British disability rights movements at least, was because of a concern that social welfare interventions were paternalistic, shut people with disabilities aside, were about taking care of people with disabilities instead of treating them as full members of society. And that is a very significant concern. And so one question I think is important for people with disabilities and disability rights advocates to engage in, and I think this is true, I mean, there are ramifications for other aspects of anti-discrimination policy, is how to create social welfare interventions that promote independence, that promote empowerment. So the push by disability rights advocates in the United States in the Affordable Care Act deliberations, right, the deliberations over Obamacare, to include in Obamacare extra spending for state programs that provide personal assistance services to people with disabilities so that they can live in their own communities, and the personal assistance can be used to help them get to jobs and participate fully in the lives of the community, right? So efforts to change the way the Medicaid system deals with disability as part of Obamacare, to create something that moves toward a universal right of people with disabilities who need personal assistance services to be full members of the community to get those services, right? That's an example of an effort that is trying to create a more robust social welfare state, but also do it in a way that promotes integration and empowerment and independence, do it in a way that may tie in well with anti-discrimination laws, that may mesh with anti-discrimination laws to get people in the position where anti-discrimination laws can help them. Now, the Affordable Care Act as a whole, I think, is a substantial step forward for people with disabilities in this regard, in the sense that one very significant reason why many people with many kinds of disabilities, it's a very various group, as I said before, were not in the workforce was because it was difficult to get health insurance from a job that provided the services that were necessary for many people with disabilities to live full lives. And the only way to do it was to be on Medicaid. By expanding Medicaid in many states, I'm in Texas, so not in every state, I will note, but by expanding Medicaid in many states to cover a broader swath of the childless working poor, right, the Affordable Care Act did help to relieve some of this problem by prohibiting various kinds of insurance practices, including lifetime caps on benefits for particular conditions. Again, the Affordable Care Act helped to address this problem to some extent. But the problem is not fully solved and has not been fully solved. And I think if I just may speak for a couple more minutes, I know I'm close to out of time, about some of the implications for other areas of anti-discrimination law. One of the things we're seeing in both scholarship and political activism is a real focus now on the limitations of anti-discrimination law in protecting women who are pregnant or who are caregivers, women who were pregnant or who recently had children. And some of this ties into questions about family leave. Sweden's got very interesting policies on that, and we might hear about. Laura's written a book about it. But some of it also ties into questions about whether maybe one approach that we might want to take to promoting the equality of women as workers in the workplace who have children is to actually forget about anti-discrimination law for a second and go for universal pre-K, right? As not a program that's necessarily going to be terrific for child development. I think that's been massively oversold. I live actually just a couple miles from the Perry Preschool study location, which is the one study everybody trots out that it turns out found some help in child development if you give them substantial education in their early years, but it eventually goes away. But if we think about universal pre-K education not as a way of developing children's skills, but instead as a way of promoting the ability of women to have children and then return to the workforce, right? That may be a very substantial assistance, and it may be more important than expansions of the pregnancy discrimination laws or the sex discrimination laws. So anyway, I think this is obviously, as you can tell, I could probably talk for another 20, 30 minutes about this. It's a very rich topic. There's so much here, but I'm very eager to hear your questions and your comments, and thank you again for having me here.
I guess it sounds like Sam and I are pretty much in agreement on everything, so I don't know if I have much to rebut. But I think that the title of the article, at least my article, was very actual for both of us, the delicate balance needed. That it's not just a question of legislation, but a question of having a way to make the legislation effective, and if that's going beyond the idea of the courtroom, but going to the question of daycare or things like that, what the society needs to make these issues be discussed and dealt with in a good manner, I think is something that legislation alone definitely can't resolve. And I think we can go over to questions now.